And good evening, everybody. This is your boy Cruz, the Beast from the East, and we are here once again on a Thursday evening. It's been an absolutely beautiful day. Currently at 68 degrees here in the Cap City. We had a high today of 71, expecting a low of 42 tonight. So, guys, don't put up the blankets yet. You just may need them, or this might be a good time to open up the windows and let all of God's air come in on you. Again, we are just pleased to be here. Hope that you're listening to Cruz Inc. Radio 102.8. You can listen to us 7 days a week, 24 hours a day at cruisincradio.com. And we're extremely proud. We have some wonderful sponsors, and we'd like to introduce our sponsors tonight. Again, thank you to Designer Creations and Candles. If you're looking for something special for your home, then you want to go to Design Creations and Candles LLC. You can find them on Facebook, Twitter, and also on IG. And Universal Mental Health Services LLC. 3 locations, one in Newport News, one in Richmond, and Annapolis, Maryland. They care about your mental well-being. You can find them also on Facebook, IG, and Twitter. And coming to the Cruz Inc. Radio family as a sponsor is JS Affairs. This upcoming June the 20th on Father's Day, fantastic show that you're going to enjoy. I'm sure, so start getting your tickets right now. Go to jsaffair.com. Jonathan Butler is going to be here, and I guarantee you that's going to be a fantastic show. So go to jsaffair.com. And again, another high-powered sponsor. We're glad to have DG Law Firm. They've been your personal injury attorneys for over 30 years. Go to dglawfirm.com and they will contact you if you have a case. It's free consultation. Again, thank you to all of our wonderful sponsors. And tonight, the young lady that we have with us, you've seen her numerous times. I believe this is number 4 in terms of being on the program with us. Our Commonwealth attorney for the city of Richmond, Miss Colette Wallace McEachin. Good evening, ma'am. How are you?
Good evening, Cruz. It's always good to speak with you and your guests.
It's a pleasure for you to be here. Again, it's been a while since we've actually had a broadcast. Back in 2020, I think before either before the pandemic or in the middle of the pandemic, we were on target, had a lot of great topics, but everybody's life changed in March, didn't it?
Yes, it did. It did. So I'm glad that we are a year past that and things look to be going up for everybody.
What were some of the adjustments, for you and your staff having to deal with all of the restrictions and things that happen, the courts in which you all are very much a part on a day-to-day basis? How was the adjustment for you and your staff?
It was pretty life-altering. I think, the court system experienced the same traumatic effects that other people experienced in their personal lives, in their business, in school. When the Supreme Court and the governor closed the courts down on March 16th of last year, we had to scramble to do all the things that other people did, but for a whole court system. So we had to find, gloves and masks and sanitizers and figure out a way to set up glass boundaries in certain places, space things out in the clerk's office, restrict people who came into the Commonwealth attorney's offices. The sheriffs in all the courthouses set up thermometers so that everyone, the facial thermometers, so everybody had their temperature checked, and that still goes on. So just so your listeners know, if they go into any of the Richmond courthouses, their temperature will be checked as soon as they get to the security area. They'll be wanded through to make sure that they don't have anything that is dangerous, and then they have to wear a mask that during the entire time that they're in the courthouse.
That's going to be interesting, especially with the new CDC policy that came out today. And I won't get into that right now because I'm sure you guys still have to have a powwow and determine how that policy is going to impact what you guys are doing, if it's going to change anything or not. So we'll say that for the next time you come back and talk about, how that policy, again, changed what you all do. Been a lot of things going on here in Richmond, a lot of things that you've been involved in. First of all, I want to say kudos to our Richmond Police Department. They did a fantastic, not just fantastic, they did a phenomenal job of apprehending those that, again, were allegedly involved in the shooting of Shy and her baby several weeks ago. Within the first 24 hours, it was 3 that were apprehended, and before the services, they had all 5. So again, tremendous job, and kudos to Richmond's finest.
Yes, I'm so proud of them and so happy to be working with them in providing justice for that entire Hill family.
Absolutely, and again, that was one of those things that I think touched everybody, and I'm sure there's going to be continual things in process, and we're going to come back and talk about those. We can't get into the specifics of the case, but we can talk about some of the things that are in the works in terms of being proactive and rather than reactive with the gun violence here in the Cap City.
Yes, and thank you, Cruz. For those of your listeners who don't know, Cruz was instrumental in creating the first rally march in support of the Hill family and against gun violence within a few days after the murders. And it was well attended, it was moving, it was spiritual, and I think it really did the community well to see that many, especially Black men, turn out in support of Black families and protecting Black and brown bodies. So thank you, Cruz.
Well, thank you as well, because you made your presence known in the community, that you have a zero tolerance for, those horrendous murders, and that you have a zero tolerance, for crime overall. If not, you would not be in that office and be as successful as you had been. So again, thank you to you and your staff for what you do, because it's not an easy job at all. You don't get, you get criticized when things are going crazy. You don't get enough praise when things are going right. So thank you for what you're doing.
I love my job. So I'm here for the citizens of Richmond.
We're talking about a lot of things that's going on. Let's get some General Assembly updates, because there are a number of laws. And let me, share with our viewers. A lot of times you guys complain to the wrong people about the laws. And I want to kind of set this in a framework here, is that everything that I know about the Commonwealth Attorney's Office is what their job is to do is to, again, execute the laws and make sure that the people that break the laws are brought to justice, and they don't make the laws at all. That's in the General Assembly. So if you got a problem with a law, then you need to contact your General Assembly person and voice your opinion about that, because this young lady here, her job and the staff is to, again, to make sure, and I hope I'm saying this right, is to oversee or take care of the part that they do in terms of when laws are broken after the General Assembly establishes that law.
Yes.
So did I frame that one pretty good?
Yeah, that was good. That was good.
So what's going on with some of the updates?
So I had to write a notebook, because the General Assembly, essentially, I think they would say they feel as though they were in session for 12 months straight. They had a special session last summer, and then that went into the fall, and then they took a break for a few months. Then their regular session started in January, and that went through March. So, and then they had the reconvene session in April for one day. So it really has only been a month since they have not been in session. I'd like to start off with talking about the marijuana laws, because that is something that everybody has been focused on for the past year. So I'm just going to roll through some things, Cruz, and please interrupt me if you think there's something that I am not clear about, or that you think your listeners would want to know. So I think everybody knows or has heard that effective July 1st, marijuana possession is legal in Virginia, but there are some restrictions. So you can possess marijuana if you have 1 ounce or less, if you are an adult 21 years of age or older, and if it's on your person. So let's talk about an ounce of marijuana. Some people may not have any idea, what does an ounce of marijuana even look like? So I talked to some people at the Division of Forensic Science to make sure that I got my math right, because it's been a while since I was taking any math courses. And they reminded me that 1 gram is a sweet and low sugar packet. So
Okay.
sweet and low packet that you would find at the restaurant,
Right.
that's 1 gram. 28 of these is an ounce.
Wow.
So I went to Walmart and I picked up some sweet and low.
Uh-huh.
And there are 28 packets in this little glass bowl.
Okay.
And that's an ounce of marijuana.
Here's an interesting question. Will there, I don't mean to be funny, but who's going to carry the scale to determine if it's an ounce or more?
That will be interesting to know. Yeah, I mean, that will be interesting to find out. There are a lot of details in these laws. I'm not going to say going to say anything else about that, other than it is legal to have 1 ounce or less of marijuana. So basically, you can have 28 sugar packets, and that's 1 ounce of marijuana, and that's legal.
Okay.
If you have between 1 ounce and 1 pound of marijuana, you would have to pay a civil penalty of $25.
Wow.
So it's still not a criminal offense. You can have up to 1 pound of marijuana as long as you are over the age of 21, not 18, 21, and it's just a $25 fine. And then it's only after you have more than 1 pound of marijuana that you can be subject to a felony of 1 to 10 years in prison and or a $250,000 fine. So basically, an ounce to a pound is no more than a $25 fine, or it's legal. So that is marijuana as we know it in the dried, chopped up version. You are allowed to grow 4 marijuana plants in your household, not per person, but in your household. So if there are 3 adults over the age of 21 in your household, you can only have 4 plants. Each adult cannot have 4 plants. So there can't be 12 plants in your household. There can only be 4. The plants cannot be visible from the street. And the plants are supposed to be individually tagged with your name, your driver's license or ID card, and a note that says for personal use only.
Uncle Joe, did you hear that? Don't be putting my name on nothing.
So I don't know what was going through the General Assembly's mind when they came up with that set of rules for growing marijuana at home, but those are the rules. I understand that part of the argument was, since it is illegal still, even after July 1st, it's going to be illegal to distribute or sell marijuana. Therefore, the only way you could legally have marijuana to smoke is if you yourself are growing it. So that is my understanding of why they said, okay, then every household can have 4 marijuana plants, so you can then grow your own marijuana to smoke and not do something illegal like try to buy it from someone else.
Now, one interesting point, and I'm sure a lot of people drop their shovels on this, is that it cannot be grown outside. So even if you have, the space outside, you cannot grow it outside. That's still illegal to do that. Is that correct in this sense? I
don't know if that is true. It can't be visible from the street.
Visible from the okay, all right.
Visible from the street. So if it's in your backyard, surrounded by trees or fencing or something like that, I think that's legal.
I'm glad you cleared that up, because you did say visible from the street, and that's totally different. You can't be sitting in the front of Broad Street with all your plants and everything growing.
Right. Exactly.
And it can only be 4 plants.
4 plants per household.
Okay. All right. You guys, all you, pharmaceutical, horticultural people out there, that's 4 plants. You can't have the whole family growing it.
Exactly. And then, of course, there are penalties for having more than 4 plants. If you have 5 to 10 plants, it becomes a civil fine. And then the range of penalties goes up. 10 to 50 to 49 plants is a class 1 misdemeanor, which is 12 months in jail or a $2,500 fine. 50 to 100 plants brings it up to a class 6 felony. And then if you have over 100 plants, it's a felony with a penalty of 1 to 10 years. So those are the restrictions that the General Assembly has set on the marijuana plants themselves versus possessing dried marijuana. There are things that you cannot do, even though marijuana will be legal in Virginia in July 1st of this year. So you cannot possess marijuana if you are under the age of 21. It's like alcohol in the same sense that you can't drink alcohol if you're under the age of 21. But alcohol, now that marijuana is legal in small amounts, underage alcohol possession is a class 1 misdemeanor, whereas underage marijuana possession is only a $25 fine. So the General Assembly has evidently decided that it is less harmful and dangerous to smoke marijuana or possess marijuana than to drink alcohol.
I guess so, because if you're smoking that thing, all you want to do is probably go and get you something to eat. I know, guys. That's how the Commonwealth turning out. We, even though we're talking serious thing, we put a little levity in this so you guys can continue to watch us.
We're not going to be talking about any kind of brownies, though.
No, all right, we'll leave the brownies and the CBD and the THC that you add to all that. We're gonna save that for another conversation.
Right, the CBD oil, right, all of that. Okay, so you can't possess marijuana if you are under the age of 21. You can't consume marijuana while you are driving, just like you can't drink while you are driving. The penalty for that is a $250 fine. You can't smoke marijuana in public. You can't give marijuana or distribute marijuana to anyone.
Oh, wait a minute. Hold on. We just got a flash on that one. All right.
Okay.
All right. So if I'm just being hypothetical here, if you smoking marijuana and a friend come over and say, hey, give me some of that in terms of maybe that ounce or whatever that you might have, that is not permissible under this law.
That is permissible if it's a gift. You can't sell or distribute it for consideration.
Okay, gotcha. So you making me go into my deep questions today.
Yeah. This is a new law, and so I'm sure that some people will end up getting tripped up over it. And so I appreciate the opportunity to use your platform to educate people so they know what to be aware of, so they can protect themselves. You obviously can't have marijuana on school grounds. As I said, you can't sell, give, or distribute marijuana to anybody for consideration. Eventually, there will be a process by which prior marijuana convictions will be expunged, but that is not happening yet because the Virginia State Police and the Supreme Court need to figure out the forms and how to look back and get that information from people's past records and things like that. So that is coming down the pipe, but that is not something that's in effect now. What is in effect, and what I decided to do because convictions still cannot be expunged is there's a little yellow card that anybody who goes to General District Court will get if they have a charge, whether it's a marijuana charge, a trespass charge, a petty larceny charge. If that charge is dismissed or null pros because you've completed community service or paid the restitution or done one of the alternatives to incarceration or diversion programs that my office supports, then once that charge is dismissed by the court, you will get this card from one of our attorneys, and the card tells you how to go to the clerk's office to pick up your paperwork to get your charge expunged. A lot of times people would be in court crews and they would have some idea that they might be able to get the charge expunged, but they didn't know where to go or how long it would take or how much it would cost. And so I wanted to provide that information to the community. And so they now know the number, where to go. They can go there. The circuit court clerk will have a packet that they can fill out themselves, so they do not need an attorney. And then the second thing I decided to do was to waive the fee that they would otherwise have had to pay to serve that expungement petition on my office. So I have waived that fee so that all you have to do is fill out the petition, walk your paperwork down to my office, file it with the receptionist, and you are done. And Cruz, you'll be happy to know that last year there were roughly 200 expungement petitions, and they were all granted. We didn't oppose any of them.
That's amazing. And again, kudos to you and your team for being proactive and helping people to start their life all over again, because that's important. Some people have been haunted by small things for the last, probably most of their lifetime. So that's awesome. Thank you so much for that on behalf of all the people that are out there cheering right now.
Well, that is how criminal justice reform is supposed to work. You have to reform the system in both big ways and small ways. And if a small way is just letting people know that they can get their charges expunged, then we're going to start there. And if the big way is, rolling out a community justice reform unit or bringing restorative justice practices to Richmond and to the 3 courts, which is the plan for next year, or bringing a law school 101 program into the Richmond public schools, then we're going to try to hit every point that we can to bring progressive criminal reform to Richmond.
That's awesome. Awesome stuff there. Really appreciate that. So what else is going on in the General Assembly and some laws that, again, that are coming down the pike?
Mm-hmm. Well, everybody, I think, is now aware that the death penalty has been abolished. And at the time that the General Assembly abolished the death penalty, I think there were only 2 people on death row. And so they have now had their sentences converted to life without parole. So that's what will happen then. But nobody will be electrocuted anymore in the state of Virginia. And I believe Virginia is the first Southern state to abolish the death penalty. So I'm glad that I spoke up in support of the abolition at the beginning of the General Assembly, and I'm glad that they were able to vote that into existence.
And just recently, within the last 24 to 48 hours, there was a national story that came out about an African-American man that had been executed. I believe the state was either Texas or Florida in 2017. 4 years later, just recently, that they found out that man's DNA did not match any of the crime scene. And so, unfortunately, we have an innocent man that was executed. And we know, and we're going to keep it real here, that more Black and brown people are executed in error or not in error. I'm not going to play judge and jury here, but we know there have been a lot of erroneous executions, and the state of Virginia and the governor, and along with your support and others, said, hey, we made too many mistakes, and one life that is executed on one person that's innocent is one too many. Yeah.
And here's the point. A lot of times the argument about whether or not to abolish the death penalty came down to, well, some crimes are so heinous, some crimes are so vicious, so horrible that the person deserves to die for what they did to another person. And that has weight, that has merit. The problem is that we are human and we make mistakes, and we can't bring back a life, to your point, Cruz, that we have taken as the government by mistake. And so since we don't have a way of making sure that when we want to execute somebody, there's not going to be some future discovered evidence or something that changes the calculus about whether or not that person should have been executed. Since we can't be perfect, we have to err on the side of justice and mercy, and that means abolishing the death penalty.
And that's, again, goes into what we're talking about, trying to find ways to maintain law and order and still keep our jurisdictions safe. And one of our Facebook viewers agrees with what you said about the law class 101 in public schools. And what I'm going to do is we're formulating right now behind the scenes this very thing of how we can all partnership together. I got the superintendent on board, so this would be something good. I think that our movement can incorporate right away. Thank you. You just became even more busier now.
It's a good thing I've got a good team of 39 attorneys who can, do a lot of work and make sure the office runs really well so that I can, help the community and be out in the community and deal with the policy issues that need to be addressed. So I have a really great office and I appreciate all of them. Well,
again, and this is a different side of that people need to understand, that you guys are not just about, prosecuting people, which that is your main job, but it's about how do we de-escalate things? How do we become proactive where we don't have our youth going from the school through prison pipeline? So again, just our citizens need to know that your office is proactive rather than reactive as well.
Yeah. And here's the thing. Prosecution does not need to be conviction. You can prosecute a case and give a voice to the trauma that the victims have suffered because they have had a crime inflicted on them, but it doesn't necessarily need to result in the offender's incarceration or in some punitive result that doesn't eventually lead to a restoration of community health and address the offender's some issues that might have caused the offender to commit that crime, whether it's mental health, whether it's a substance abuse disorder, whether it's homelessness, whether it's a dysfunctional family. All our attorneys look at each individual offender who comes before us and tries to figure out how we can address their issues so that we don't have to see them again and so that they don't have to see us again. And that is what makes a healthier community. And that's what hopefully prevents future victims. And that's what we all want, is fewer victims in the future.
Yes. All right. So we have anything else from the General Assembly? We can come back and continue, because our next segue after this commercial is talking about some of how these new laws are going to impact citizens in the Commonwealth. So what we can do is go to a commercial break here and have a word from our sponsor. Then we can continue that conversation along the lines of General Assembly updates and also the impacts of some more of the laws that you have written down and to reveal to us.
All right.
All right. We'll be right back, everybody. Now a word from our sponsor.
Each case is totally different. I can't give you an exact time frame of how long it will take your case, but I can explain how long it takes based on phases. The first phase is your treatment phase. I don't know how long it takes you to get well, but that's the first phase. The second phase is a phase where we're gathering medical records, medical bills, and everything and sending it to the insurance company for processing. The third phase deals with negotiations. Sometimes that's short, sometimes that's long. If negotiations break down, we're into the trial process. If you file your case in the General District Court, you'll probably have a hearing in about 4 or 5 months. Those cases cannot get any more than $25,000. If you file your case in circuit court, the sky's the limit. You can ask for any amount you want. It will take between 8 to 10 months to get a verdict. Understand that at any point through this process, your case can settle. There's still settlement negotiations going on, even though the court process is working. So if the case settles, the court process is over. The most important part is for the client to treat with his or her doctor and get well. We will take care of everything else.
Again, big thank you to one of our sponsors, the G Law Firm. Go to theglawfirm.com if you need a free consultation. Again, they have been serving Richmond and the Commonwealth for over 30 years, and they are a proud sponsor of Cruz Inc. Radio 102.8. All right, we're back. Thank you for, again, being with us. We're currently talking to the City of Richmond's Commonwealth Attorney, the Chief Law Enforcement Officer in the City of Richmond, Ms. Colette Wallace McEachin.
Good evening again.
We were just talking about, Colette, some of the, again, the General Assembly laws, and we want to talk about now the impact of some of the other laws that are going to affect July the 1st. And want to let everybody know, again, talking about the marijuana, that doesn't go into effect until July the 1st, right?
Yes.
Okay, so the law as of right now, and the reason I'm asking this is because we don't want people to get tripped up thinking that they can have an ounce right now. At this state, it is not legal until July the 1st. Is that correct?
That is correct.
All right.
Yeah, so
and we're talking about the impact of the law. So now, and I don't want to. I'm trying not to give anybody any, I guess, false senses here. But most people say, "Oh, well, it's only it's the middle of the month, and it'll be July the 1st here a little bit. I can go ahead and then will they give me a grace period on that?"
There is no grace period. No.
Oh, okay.
There is no grace. I will say that obviously recognizing that it's going to be that 1 ounce or less is going to be legal for the past couple of years, our Commonwealth Attorney's Office has made the decision that marijuana prosecution should be minimized. And that if you were charged with marijuana, as long as you went to a drug education class and did community service, the charge would be dismissed. And so there have been very few people who have been convicted of simple marijuana possession in Richmond in the past few years. And then once marijuana was decriminalized last year in 2020, not legalized, but decriminalized, it just became a civil penalty, which is what it's been since July of 2020. So that's where we were. So we went from marijuana being illegal to marijuana being illegal but not criminal. And now starting July 1st, it's going to be legal as long as you have 1 ounce or less.
I'm so glad you broke that down because, again, that's important for people to know. Again, you don't want to talk to your homeboy about, what's the law and stuff. You probably want to make sure that you're within that law. And, again, if you can just break down that structure one more time in case the people in the back didn't hear that, how this process has come from one level to the next level and kind of expound on those levels again.
Sure. So to repeat, marijuana used to be completely illegal. Then last year, the General Assembly said it's still illegal, but it is no longer criminal. We will decriminalize it so that if you have marijuana, it is just a civil penalty. And now they have gone to the last step, which is to say possession of 1 ounce or less of marijuana is legal as long as you are over the age of 21.
Thank you. Appreciate that. Again, that clarifies. And if you missed that, you can always send go to, is it anywhere on the website or Colette where this information can be found, like on the General Assembly website or?
Yes.
Okay.
Yeah. And you can just punch into Google, marijuana laws in Virginia, and they will tell you what the law will be as of July 1st.
Awesome. What else do we have coming down the pike that's going to impact us as Virginians?
Yeah. So a couple of things. And once again, stop me if there's something that you think is particularly interesting. Some of your listeners might have been aware that if you were charged with a third petty larceny, that was automatically a felony petty larceny. And any subsequent petty larceny would be charged as a felony petty larceny. So your first petty larceny, class 1 misdemeanor. Your second petty larceny, class 1 misdemeanor. Your third petty larceny, that would have been a felony. It could have been amended or broken down, based on your making restitution, but you would have been charged with a felony, and that's what would have shown up on your criminal record. The General Assembly has now changed that, and so there is no more felony petty larceny statute in the Commonwealth. No matter how many times you are charged with stealing something, it will only ever be a petty larceny. And a petty larceny carries a penalty of 12 months in jail and or $2,500 fine. But felony petty larceny no longer exists. Just similarly, the habitual offender statute, which some people were burdened with and which prevented them from getting their driver's license and therefore getting to work, getting a job that required a car, that type of thing. The General Assembly has repealed the habitual offender statute. And so that statute no longer exists. And DMV is now required to reinstate your license if the only reason that your license had been revoked or suspended was because of a habitual offender determination by the court.
Question, Colette, as we talk about that, and again, this is going to be kind of like a speculation question and perhaps answer as well. In terms of your office, with the new laws now coming into play, will it decrease some of the burden that in terms of caseloads that you guys are having to deal with at this particular point in time that are, like I said, kind of minimal offenses? Will we see a decrease perhaps in that?
It won't decrease our workload because the General Assembly has imposed other requirements on our office that are increasing our workload. So we have increased requirements under the Freedom of Information Act. We have increased requirements under the new discovery rules. So there are other things that are causing us to have to work just as long and just as hard, but not on relatively minor criminal offenses.
Okay, appreciate that answer, that clarification. All right, what else have we got in the book and the log over there?
In the law book. So we're all aware of the tragic murder of Breonna Taylor that was based upon the execution of a no-knock search warrant. And the Virginia General Assembly, in response to that, has abolished the no-knock search warrant. And so from now on, two things. If the police are going to execute a search warrant at your residence, it has to be done in the daytime. If they have to or want to do it in the nighttime, they have to get prior approval from either a magistrate or a judge. And when they execute the search warrant, they have to be, at least one person has to be in a police uniform or identified as a police officer. They have to announce themselves as police officers in loud voices, and they have to tell you that they have a search warrant to enter your residence. So there can't be any more banging down your door without any type of notice or warning.
Yeah, and of course, we know that made national attention, and most homeowners that again have a personal weapon in their home to protect their home. When somebody crashes through your door, you don't know the difference between if it's an officer or a home invasion. So glad to see that that law has been changed here, and hopefully that will be something that will be addressed across the country and in every jurisdiction, because we know the likelihood, again, especially those that are maybe in high crime area and they're law-abiding citizens, their weapon is registered, and again, somebody's coming in your home at 2:00 in the morning, and you can't tell who they are because they're dressed in all black. That's a recipe for disaster, and we saw that firsthand.
Yeah. I think hopefully this law will actually protect both the civilians, the homeowners, the occupants of the residence, and police officers, so that no one is shot at or harmed because of surprise or error. So now there are particular rules that police officers have to follow before they can execute a search warrant, and it has to be done in the daytime or only in the nighttime with judicial approval.
Now, again, another, got to give kudos to our General Assembly for wanting the narrative to be changed in terms of reformation and not having to deal with that type of incident in the Commonwealth, hopefully eliminating that. So, again, kudos to them on that.
And then finally, Cruz, just a couple of points. One, some of you all may know that if you were in a traffic stop with a police officer and they gave you a ticket, you were supposed to sign the ticket, and the officer tells you, and it says on the ticket or on the summons, that signing the ticket is not an admission of guilt. It's just an acknowledgement that you are aware of the charge and that you're going to come to court. And we've all seen the horrible killings of African-American men and women who were involved in traffic stops and then refused to sign the summons or ticket, or something developed that led to shooting and sometimes death. And so the General Assembly has now said that if you get a traffic ticket, you do not have to sign the summons. You can refuse, and the officer will note that you have refused, and then the officer will release you. It used to be that if you didn't sign the summons, you could be arrested for not signing the summons, because the court looked at that as you're being in contempt of the summons. And the General Assembly has now said the officer just needs to note that you refuse to sign the summons, and you can be about your way. And hopefully that also will minimize or eliminate a lot of the horrible interactions that happen in a lot of traffic stops.
That's also interesting to note, and again, proactive. We got a question coming in, Colette, and again, you may or may not be able to address this. Are there laws being considered regarding body cams in Virginia? There was conversation about officers being reprimanded in some form for not having their body cams operable. Again, I don't know if that falls up under your auspices of elaborating on this, or is that something, again, with the General Assembly and or with the Chief of Police?
So yes, Cruz, you're right on those last two things. I don't have anything to do with it. The Commonwealth Attorney's Office doesn't have anything to do with that. That would be directed at either the General Assembly to create a law that says that. Right now, the situation is that many, but not all, police agencies have body-worn camera for their officers. So Richmond does, Henrico does, Chesterfield does, Some of the outlying jurisdictions, I don't know, because it costs a lot of money to buy those cameras, and the county has to be willing to pay for it. And then once the county or city buys the body-worn camera equipment for their officers, the police department is the one that sets up its own regulations about when it will be turned on, when it will be turned off, and that type of thing. And that's solely within the discretion of the police department. There isn't any statewide law that says when the camera has to be on and when the camera has to be off. And so it's very much done by local jurisdiction.
Got one other question here, and again, we're going to kind of frame this. To your knowledge, is there any new bond reformation that is being considered, has been considered within the last, say, 12 months, to your knowledge?
A bond? Is that what you're saying? A BOND?
Right.
I don't know if this answers the question. I know that the General Assembly has removed the rebuttable presumptions for some bond. And so for your listeners who may not know, if you were arrested and you were held by the magistrate until the next day of court, you would have a bond hearing. And your attorney would argue that you should be released, and the Commonwealth, depending on the facts, might argue that you were too dangerous to be released to the public and that you should be held for the safety of the public, or because there was evidence that you would not come back to court. There were also a list of rebuttable presumptions. I think maybe we got up to maybe 15 or 20 different rebuttable presumptions. And so prior to this year, prior to July 1st, if you were charged with murder, rape, aggravated malicious wounding, being part of a drug distribution gang, and a host of other things, there was a rebuttable presumption that you should not get bond. Your attorney could try to argue against that, but you started off with a rebuttable presumption that you would not be eligible for bond. That rebuttable presumption is now gone, and so the court now just has to weigh whether or not the court thinks that it would be a danger to the public or to yourself if you were released, or if the court thinks that you will not come back to court if you're released. If the court doesn't find those two things, then you will be released on bond.
Okay, I appreciate you clearing that up. We're going to take another break here, and then we're going to get into another topic that people, especially our viewers, are going to be interested in. That's the upcoming election. And I got some specific questions that I want to ask you in terms of your platform versus, your opponent here. So everybody, will be right back. Another word from our sponsor, the G Law Firm.
Anyone can be sued for a personal injury case if they are at fault. For instance, if you did something wrong and you are within the scope of your employment, that means you are doing the work of your employer and you wrecked. That causes you to be sued and your employer to be sued also. And oftentimes there is a dispute, and that's when we have to get good consultants, we have to get good engineers, we get experts in that field to try to help us convince a judge or a jury. Also, we always scour the neighborhood to see who's outside, see if there are cameras on the street, see if anyone was in their yard and they actually saw this, to see if we could find some of those individuals, because they're the eyewitnesses. They can help determine the facts of the case.
All right, we're back, and once again, I'd like to thank our sponsors, the G Law Firm, Universal Mental Health Centers, Designer Creations and Candles, J&S Affairs. Again, if you love good music, you want to go to jsaffair.com. Jonathan Butler. All you ladies are looking for a gift to give the father, take them to the Jonathan Butler Show. I like. So don't say that you don't know what to get your husbands and brothers and everything. Buy that ticket. It's going to be outside concert, all social distances, policies will be adhered to. And again, the way it's going to be set up, you will be safe and you will have a great time. So get those tickets today. Make that phone call. It's like I feel like I'm doing a marathon or something, like trying to raise that money. No, but seriously, we need to support our African American businesses. And again, JS Affairs is one of those. He's been doing this for over 30 years here in the Cap City. He's bringing Mesa, who is coming. I believe in August, he has Gerald Albright that will be coming back, and just a host of other fine entertainment to the Cap City. And also, we want to welcome in Smoothie Queen. If you like smoothies, you can go to their website on Facebook for the Smoothie Queen. All right, we're back in the home stretch now, coming down the pike. What I want to talk about, first of all, let our viewers and listeners know when the election is coming up and what they can do now in preparation for the election. Then we're going to kind of talk about your campaign as well.
Sure. So the general information is that there is a primary election on June 8th, which is the second Tuesday in June, so a little less than a month away. Early voting has started in Richmond, so you can vote at City Hall during business hours, or you can vote at the main registrar's office on the Burnham Avenue. And I believe you can also vote on South Side at the Hickory Hill Community Center. Early voting will stop, I think, maybe June 1st, and then you have to wait until June 8th for the primary. And it's a Democratic primary. I'm running for re-election. The sheriff is running for re-election. And then the governor, lieutenant governor, attorney general, and some members of the House of Delegates are also running in the primary. So it's going to be a big election. It's going to be important because in Richmond, generally the person who wins the primary, a Democratic primary, goes on to win the general election in November. And so I urge everyone to, if you're not registered, to get registered. I think there's still time. And once you are registered, to exercise your constitutional right and vote.
Absolutely. And I certainly appreciate that. And they can go to, if I'm not mistaken, our election board to see who's running and what positions. Is that correct?
Yes, the registrar of voters, yes.
Absolutely. Now, you have one opponent in the race. The first question is, how long do you have, are you in office before you have to run again? I wasn't sure if it was 2 years or 4 years.
So my situation is a little odd. I have been with the Commonwealth Attorney's Office for 25 years, and my predecessor, Mike Herring, was the Commonwealth's attorney for 12 years, but then decided to resign in the middle of his term. And so I was the interim Commonwealth's attorney until there was an election. I ran for the post and I won. And so I was elected Commonwealth's attorney in a primary in August of 2019. I was sworn into office January 2020. We know what happened in 2020 between COVID and the protests in the summer. And so I've had 1 year in office as the elected Commonwealth's attorney. Now I'm running for my own 4-year term beginning this year and then for the next 4 years.
So, all right, everybody, it's 4 years. It's not like some of the offices here in the Commonwealth where it's a two-year turnaround time. So, all right, awesome. Now, Colette, draw that line of demarcation between you and your opponent. Some things that are clearly, again, that will resonate with our listeners and with the voters in terms of where you stand and your platform.
Sure. Thanks for the opportunity to make those points clear. First of all, as I've said, I have dedicated my life as a public servant to being a voice for victims of violent crimes in the city of Richmond. My opponent worked in our office for 10 months and then left. And so I would put first my 25 years of experience and living and working in the Richmond community against his 10 months. Secondly, he has had very little actual trial experience. Obviously, given the fact that he's only been practicing for a few years, I have practiced in both the general district courts, the juvenile courts, and the circuit courts. I have had cases involving child abuse, incest, neglect, domestic violence, rape, robbery, aggravated malicious wounding, shootings, the whole spectrum. And so I have a deep and broad knowledge of the trauma that is inflicted upon victims when they are touched by crime. At the same point in time, I have also been active in crafting alternatives to incarceration and diversion programs, recognizing that there are a lot of nonviolent offenders who need to have the root causes of their issues addressed so that they do not continue to reoffend. So Richmond should be very proud of the fact that it was one of the first jurisdictions in the Commonwealth to have an adult drug court, and that adult drug court is still going strong and managed to continue even through the pandemic. I was one of the people who worked on creating the mental health docket in the General District Court, and that docket is also going strong in its 11th year and continued to go strong in the pandemic. And then we also have a behavioral health docket in both circuit court and in the juvenile domestic relations court. So my experience on both sides of being a voice for victim and also addressing the social and behavioral and mental health needs of a lot of our offenders so that they do not reoffend is what separates me from my inexperienced opponent.
That is, again, we certainly appreciate you breaking that down. We have about another minute or so left, and we can always, if it takes you longer to expound on some things that we have not talked about. But apparently, again, there's another question. Maybe I didn't quite frame the other question about the bond, BOND situation. So let me just put this up here. If it needs to be addressed in another form, let me know if it's, can you see that question there?
I can. Let me read through this.
Okay.
Are there reliable? States that abolished bail. Okay, so I'm going to give this my best effort, and we'll see if this addresses it. So, used to be the case before my office and the courts decided to not use cash bonds and oppose the use of cash bonds, is that if you were given a bond by the court of, say, $2,500, then you needed to usually find a bail bondsman and give that bail bondsman 10%, $250, and they would essentially promise that they would make sure that you would reappear for court. Well, the problem that the criminal justice reform movement and the courts saw with that is a lot of people didn't have $250. And so if that was the amount that had to be posted as directed by the court, then people stayed in jail because they didn't have a relatively small amount of money to pay a bail bondsman. So in the city of Richmond, the city developed a Department of Adult Programs, and it's called DAP, D-A-P. And the Department of Adult Programs is the one that monitors people who are now released on their own personal recognizance. And so people are told by the court, you're not going to have to pay a bail bondsman or have a cash bond. You are released on your own recognizance, but you have to go to the Division of Adult Probation, and you have to do what they tell you. And if they tell you that you have to wear a scram bracelet for your alcohol, to monitor your use of alcohol, you have to do that. If they tell you have to go to drug treatment, you have to do that. If they tell you have to go to an anger management program, you have to do that. And the staff members of DAP monitor whether or not the person complies with what they are telling the person to do. And if they don't, they report that back to the court, and the court then issues a show cause or a capias for the person's arrest. And then they are then brought back to court, and the court can decide whether or not to hold them until their trial or to give them a second chance and release them again on their own recognizance, or perhaps with a secured bond. So that is the way that the bail bond system works in Richmond now.
So, and does the severity of the crime come into play as well in terms of whether the judge and the magistrates deem this person is bondable? Is that still part of the consideration as well?
It is, yes.
So it's not just a free get out of jail card. It's a lot of variables, a lot of things have to still be considered in terms of those PR bonds.
Correct. And there are times when my office opposes bond because we think it is too dangerous for the person to be out, whether it's a domestic violence situation or it's a very violent crime, or it's a situation where the person's criminal record has demonstrated that if they are released, they're not going to come back to court.
Well, Colette, as always, we appreciate, first of all, your transparency in the office and being available to talk about sometimes the things that are weighing on the minds of our citizens, as well as those things that may not always be comfortable and people may misconstrue, or whatever the case may be. You have been extremely open and, again, accessible to our audience and to the city as well. We'll certainly appreciate that. So I want to give you an opportunity to give out any shout outs, any other bulletins, anything that announcements that you would like to make for our viewing audience and those that may listen to this in other forms through our YouTube channel after we air.
Sure. Well, once again, thank you so much. It's always a pleasure to be on your show. And I'm always happy to educate and inform your listeners about what the General Assembly is doing and then what is happening in my office. When I ran for office, I wanted to make sure that people knew that the Commonwealth Attorney's Office was not something in an ivory tower, that it was accessible, that I was accessible as Commonwealth's attorney. And so to that point, I will give out my telephone number, which is 646-3500, 646-3500. And you should
I'm going to put that up one more time, 804.
646.
646.
3500.
3,500. All right, guys. Y'all see that sometimes we, if I had an engineer, I don't have that staff like that. But now here's the number again, so that again, as you look at this broadcast, you'll be able to have the number. It's scrolling across the screen now, and I'm sorry about the Colette, but I want to make sure that we get that number on record in this broadcast.
Yeah, no. I want people to call me, and if you call that number, the receptionist will leave the message for me, and I will call you back. So I am not a standoffish Commonwealth attorney at all. I want to have a conversation, because if you care enough about an issue, then I need to care about it too. So that's the first thing I will say. So thank you, and a shout out. My first shout out is to you, Cruz. Thank you so much. And secondly, I hope that in the past year that I've been Commonwealth's attorney, that you have seen the good works that I've done. I hope that you have heard my message about reform, restore, and rehabilitate within the city of Richmond, and the need to bring restorative justice principles instead of criminal justice principles to Richmond, so that the community and offenders and victims can restore their relationship with each other and divert away from punitive measures. And so that is something, in addition to the Law School 101 program, that I'm going to be focused on in the coming years, Restorative Justice and Law School 101. And then, of course, if anybody wants to call that number and find out about our Community Justice Reform Unit that I have now created, if you have any interest in lending your voice to that, once again, please call 646-3500 and leave your name and information, and someone will be in touch with you. But it's all about our office being accessible and available to the community so that they can see the progressive criminal justice reform results that are happening in the city of Richmond every day.
Again, we certainly appreciate it and want to say to our viewing audience tonight, thank you for tuning in with us. If you missed any part of this, you can always go to our Cruz Inc. Radio 102.8 TV YouTube channel. All are including previously aired where you have Miss Colette McEachin all the way back to the very first episode is out there, and you can go back and see that as well. Again, we're about informing our community, making sure that knowledge is power, and that we're doing our job as a media network, media outlet to bring you information that we deem important, especially here in the Commonwealth. So thank you, as always, for supporting us. If there's anything that you would like for us to talk about, or you'd like for Ms. McEachin to address in another broadcast, send us an email at cruisincradio@gmail.com. That's cruisincradio@gmail.com. And she's not afraid to talk about anything. So, you know, one thing I love about it, if it's sensible, reasonable, and not foolishness, she'll address it. And if you come out with some real foolishness, you might get the answer that you didn't want. No, but seriously, she's thank you as always. And we're gonna have another commercial. Don't go anywhere, Colette. And everybody. One of the things I want to say is always, whatever comes from the heart reaches the heart. Let somebody know how much you care about them, not just in words, but in action. And we have a lot of work to do here in this community. So if you want to get involved, you're going to hear more about Virginians in action. Colette's office is involved in this. The police department has committed, the superintendent, the board of education. I said board of education, but it tells you how old I am. I don't even think they use that terminology anymore. But the Richmond public school system is on board. The Commonwealth Attorney's Office, as I indicated, the sheriff's office. So we have several entities that are interested in proactive measures to help stop the violence in our area and to reach our kids, because we see more and more of our young people that are dying and committing heinous crimes, and we have to stop that. It's enough talk about it. We got to be about it. So again, thank you for tuning in tonight. Another word from our sponsor. Thank you again, everybody. Have a great night.
Anyone can be sued for a personal injury case if they are at fault. For instance, if you did something wrong and you are within the scope of your employment, that means you are doing the work of your employer and you wrecked. That causes you to be sued and your employer to be sued also. And oftentimes there is a dispute, and that's when we have to get good consultants, we have to get good engineers, we get experts in that field to try to help us convince a judge or a jury. Also, we always scour the neighborhood to see who's outside, see if there are cameras on the street, see if anyone was in their yard and they actually saw this, to see if we could find some of those individuals, because they're the eyewitnesses. They can help determine the facts of the case.